Monsieur le Président.
Thank you, Mr. Chairman.
Back to the home cultivation issue and the potential conflict between provincial law and C-45 in the case of Quebec and Manitoba. So I want to make sure I understand the position that you stated in your presentation. Do I understand, therefore, that you would leave the government of Canada would leave it totally to the courts, that the government of Canada does not have a position on the fact that two provinces have legislated so that there would be no home growth on their territory, and that the government of Canada would not, if I understand correctly, would not seek intervenor status or would not intervene in such cases if there was eventually such a case?
Well, thank you for the question, and I hope I understood the question correctly, Senator. We have been working very closely with the provinces and territories to ensure that we continue to engage and clearly speak about the purposes of Bill C-45. That includes up to a maximum of 4 plants that individuals can grow in their private dwellings. I understand that there are a number of provinces that have brought forward legislation that proposes zero home cultivation. I've been asked this question before. It is not the intention of the federal government with respect to home cultivation to challenge provincial laws. I suspect that there could be a potential for an individual who lives within the jurisdiction where it's legislated no home cultivation to challenge that law. And if that is the case, it would go to court and there would be discussions about what the conflict of laws, if there is a conflict of laws between the provincial and the federal law, and that if there is a conflict, then the federal law will prevail.